Good afternoon. Thank you for joining us today with our What You Need to Know About Handling Your First or Next Termination Adoption CLE case. I'm Catherine Saldana. I'm one of the mentor attorneys with DVAP, and we are so blessed and fortunate to have Jenny Womack be our speaker today. Let me tell you a little bit about the kind of cases we take. The majority of adoptions that we take are usually family members who have raised children, sometimes grandparents, like raising a grandchild, or an uncle or an aunt raising a niece or a nephew. And sometimes we get step-parent adoptions. And most of ours tend to be voluntary relinquishments, unless we can get somebody like Jenny to take the more challenging ones that are contested. But for the most part, anything you want to know about adoptions, Jenny's the right person to be speaking to us today. She has been our speaker for maybe, 10 years now, I think, at least.
A long time.
Yeah, long time. She received her license in 1998 from the University of Texas School of Law. In 2004, she was asked to join the American Academy of Adoption Attorneys. And then again in 2011, she was asked to join the American Academy of Assisted Reproductive Technology Attorneys. And now those two groups have formed together, and they are the Academy of Adoption and Assisted Reproduction Attorneys, a very prestigious organization of close to 500 attorneys nationwide and abroad as well. In May of 2023, she completed her first year as the president for the Academy, and has served in various leadership roles prior to that. Locally, she is a member of the Dallas Bar Association. She was been on the as a director of the Dallas Young Lawyers Association, and she's also been a director on the Dallas Women Lawyers Association. Since 2012, when she opened her firm, she has focused mostly on family formation, adoption, surrogacy, and other assisted reproduction matters. And she speaks on various topics, including one coming up on Friday with the State Bar. So let me turn it over to Jenny, and she will give us all the information we need so we feel comfortable taking adoption cases. Thank you.
Great. Thank you, Kathy. I appreciate that. I know that my camera and my audio are not in sync, and I'm sorry about that, but we're going to go to my slideshow, so you won't be having to watch the off-sync stuff for very long. I will ask that you do questions and answers through the Q&A block down at the bottom, and I will answer them at the end. So with that being said, let's go ahead and get started. Let me pull up my screen here so you can see it. And today we are talking about, if I can get it to go in presentation mode, here we go. Today we are talking about what you need to know about your first or next termination or adoption case. First thing you need to know is adoptions are state specific. So for us, that means you're going to find the stuff in the Family Code. Chapter 162 is adoptions. 161 is termination. 152, you got your jurisdiction statutes, and 102 and 107 have some other things like about the home study and about an amicus or an ad litem, things like that we're going to talk about as we go forward. There are two steps to any adoption. So that first step is going to be terminating parental rights. The second step is the actual final adoption. Child is supposed to be in the home at least 6 months before you complete the final adoption. These can be done separately, and in fact, most of my cases are newborns, and so they are done separately. But if the child has been in the home for a while, you can combine it in a single suit, and we'll talk a little bit about that when we're talking about the pleadings, how you might want to do that. So a lot of times with the step-parent adoption, where I'm also having to terminate, or with a lot of the DVAP cases where you do have these relatives who've had the child for months or even years, it may make sense to just combine them into one suit. Jurisdiction, as with any other case, you got to have your personal jurisdiction, you got to have subject matter jurisdiction. As with any other case, personal jurisdiction can be waived. It's not fatal if it's lacking, whereas subject matter jurisdiction can't be waived, and any order issued that doesn't have subject matter jurisdiction is void. So you got to look to the UCCJEA. It does not by its own terms, cover adoptions, but it does cover terminations. So if you are terminating parental rights, you do need to look at the UCCJEA. You need to consider, is there a court of continuing jurisdiction? If not, then you got to look at, what are the bases? Is it home state? Has the child been here for at least 6 months or since birth potentially? Standing, again, every other case we do, you always got to have your standing. Different people have standing. I've listed them all pretty much here. You've got the department, child placing agencies, people who are designated in an unrevoked relinquishment, which is actually what a lot of my cases are, is either that or agency related. But step parent or adults who've had possession for, again, not more than 2 months in the preceding 3, that kind of thing. Foster parents, there's a slightly different rule for them. They actually have to have the child for a year, but most of what you're likely to see is probably going to either fall under they're designated in a relinquishment. They already have managing conservatorship from a previous order, like maybe a CPS order, or again, with the DVAP cases, a lot of times it's going to be somebody who's already had this child in their home for months or even years. Interstate compact. So this doesn't crop up much for DVAP cases, but in private cases or a lot of my agency cases, because I do represent a couple of adoption agencies, are interstate, meaning child is in one state, adoptive family is in another. So there is a compact that has been adopted by all 50 states called the Interstate Compact for Placement of Children, or ICPC for short, that basically says before the child can cross state lines for the purpose of adoption, you got to have approval of both the sending state and the receiving state. The only exceptions are for very close relatives, step parents, grandparents, aunt and uncle, or adult siblings. I don't list that there, but that's also true. If it is, for example, it has to be the aunt or uncle of the child or the grandparent of the child, not aunt and uncle of the parent. That's 1 degree too far. They still have to do ICPC. Compliance is mandatory, and every termination and adoption suit that you file does have to have an affidavit stating whether you've complied, and if you haven't complied, why not. So if everybody's in Texas so that you don't have to comply, it doesn't apply. Or if it is a step parent case or grandparent or aunt and uncle, you still file an affidavit. You just say you don't have to comply because it's a step parent adoption, or you don't have to apply because everybody's in Texas. It's not interstate. If you are having to do an interstate case, you have to put together a big packet of documents that goes to the sending state first, then to the receiving state. It's a whole big deal and a little bit beyond the scope of what we're talking about today. But if you end up in that scenario, I highly suggest, if it's your first one, you get with an attorney who's experienced in handling them to help walk you through it. Because if you do it wrong, you end up with people who get stuck somewhere for a long time while you get it straightened out. So you want to make sure you get it done right the first time if possible. Couple of warnings to be aware of, things that can kind of be a little sneaky. First is hidden international adoptions. If the child in question, child being adopted, is not a U.S. citizen or legal permanent resident, you are probably looking at something that's an international adoption, even if the child is in the United States. And so international adoptions, you often have to involve accredited adoption service providers and things like that. If it ends up a child, and I do get these calls where child is here, but is either undocumented or is here on just some sort of a temporary visa. Those are potentially international adoptions, and you got to be really careful about that. Because if you do them wrong, the child may not be able to get citizenship. Another thing to be aware of are secondary placements. I don't run into these too often because, again, most of my cases are newborns, so they haven't already been adopted. But if you've got a situation where the child is previously adopted and that adoptive placement is now wanting to place the child elsewhere, so secondary, hence the concept of a secondary placement, there are restrictions on handling that. that do involve criminal liability. So I've noted the code sections here about that. Another thing to be aware of is in any adoption, you cannot provide financial assistance except through an agency. So our baby selling statute, which is in the penal code, chapter 25, I think it's just 2508, but I'm not 100% sure I got that right. Might be 09, somewhere in there. You cannot provide anything. You can do legal, medical, counseling relating to the adoption plan and the adoption placement. Nothing else except through an agency. Agencies can pay reasonable and necessary living expenses during the pregnancy and for a short time afterwards. But if you're talking about a child who's a little bit older, there's no financial assistance available. It's just you can cover the legal, medical, and counseling if they want it. So let's talk about this 2 steps. The first step, again, like I said, is termination of parental rights. So you can terminate voluntarily or you can terminate involuntarily. So when you're doing a voluntary termination, that's when you've got birth parents signing their rights voluntarily. So with the birth mom or expectant mom, she would sign an affidavit of relinquishment. That can't be signed until at least 48 hours after the baby's born. There's specific things that have to be included. Can also include a waiver of service, which I always do. If it is signed to an agency, whether it's the department or a private agency, it can be irrevocable when signed. If it is signed directly to the adoptive parents, however, it can't be. It's either going to be revocable for 10 days, becoming irrevocable on day 11, or it could be irrevocable for 60 days and becomes revocable on day 61. Irrevocable. I'm getting that backwards. Revocable for 60 days becomes irrevocable. No, I'm still getting it backwards. It's irrevocable for 60 days, revocable, and then it becomes revocable after 60 days. I don't use the 60 days very often because it's pretty rare to actually get into court and get the termination done that quickly anymore. I use the 10-day, and it's revocable for 10 days. Day 11, it becomes irrevocable. Only way to undo it, fraud, coercion, prove fraud, coercion, or duress. You got to have 2 witnesses and a notary. If the Indian Child Welfare Act applies, and we're going to talk a little bit more about that in a bit, you've got to take some additional steps as well. And you can't have any conditions like post-termination contact in the relinquishment. Then you also got to deal with the father. So there are basically 3 types of fathers. You've got a presumed father, which is the husband or recent ex, divorced within 300 days of the birth. You've got an acknowledged father, which means that they've signed an acknowledgement of paternity, usually at the hospital. An adjudicated father would fall under the same concept if they've actually got a court order saying he's the father, would fall under the same category as a presumed or acknowledged father. And then you have an alleged father, which is basically any potential father who is not presumed, acknowledged, or adjudicated. For the presumed, adjudicated, or acknowledged father, they're treated the same as the mother. They have to sign an affidavit of relinquishment. You have to deal with them even if they aren't the biological father. So more often happens with the presumed than an acknowledged or adjudicated father. Usually they're going to be biodads, but it's not uncommon that you've got some estranged husband out there who is not the biological father. You still have to terminate his rights, and to do it voluntarily, you have him sign a relinquishment. Like with birth moms, can't be signed until 48 hours after the birth, so no pre-birth signing, has the same revocability, all of those things. An alleged father, on the other hand, signs an affidavit of waiver of interest. That can be signed at any time, including before the birth, and it's irrevocable even in the private independent placements. It does not have to include an admission of paternity. And in fact, I have had guys ask me to specifically state in there that they don't believe they're the dad. And so I will do that, where I will say they understand that they've been alleged by the birth mom to be the dad, but that they don't believe they're the dad. And it can't be used by anybody else against him to establish his paternity. That's also a fear I get a lot from guys going, I don't want them to use this to establish child support for me. Can't be used that way. It can only be used by the persons named in the affidavit of the waiver of interest to terminate your rights. Now, if you have a parent who is not signing either an affidavit of relinquishment or an affidavit of waiver of interest, you're going to have to involuntarily terminate their rights. There's a long list of grounds listed in the Family Code in 161.001. That's where you find the abuse and neglect grounds, failure to pay child support for over a year, things like that. If you're dealing with an alleged father, not presumed, adjudicated, or acknowledged, but an actual alleged father, we do have a paternity registry. It basically says a man has until 31 days after the baby is born to register his intent to claim paternity, and he is entitled to notice of any proceedings that affect his rights. Now, if the child is under the age of 1, you can terminate an alleged father for failing to register with a paternity registry without even giving notice to him. Again, you got to have your paternity registry certificate and all of these things, but you can do that. Now, if you do name him in the pleadings, there's conflicting case law out there about whether or not that then means you have to serve him. So, for example, lots of my cases, we have newborns, so they're under the age of 1, and the alleged father is not in the picture. Sometimes birth mom either doesn't know his name or refuses to identify him, which she can do as long as they're not presumed, adjudicated, acknowledged. Alleged father, she can refuse to name him. And I will use a paternity registry to get rid of those guys. If the child is 1 or older, you have to do due diligence to identify and locate them. If the man files with the paternity registry, then you're going to have to file and serve him. So there's always a lot of things in there. I usually, in my cases, terminate potential unknown, unnamed, and unidentified fathers based on their failure to register with the registry, even when I have a named dad who has signed. Unless I've got DNA proving to me that the guy who signed is dad, I actually use paternity registry to get rid of unknowns. You still have to prove up all of your grounds for termination by clear and convincing evidence. And you always have to prove child's best interest, whether it's voluntary, involuntary, always have to have child's best interest. In your petition for termination, getting into some practical tips, I include all the potential grounds usually. The only exception would be if I am using that failure to register with the paternity registry and I'm not serving the alleged father either because he's unknown, or maybe, birth mom doesn't want him notified because he's abusive. There's some reasons why. You need to allege best interest. I always attach the relevant documents to my petition. You've got to have that ICPC affidavit. You might need a 152.209 affidavit if you've got parties out of state. The relinquishments or waivers. Usually I do not have my paternity registry back in time, so I file that separately. But if I do, I file that as well. The caption should only have the child's initials, and you need to have that sensitive data notice up at the very top. I usually do not file until the relinquishment has been signed, unless it's, of course, a fully contested or fully involuntary, and I'm having to serve everybody. So speaking of service, pretty much anybody who doesn't voluntarily relinquish are going to have to serve, again, with the exception of an alleged dad of a child under 1 who does not register with the paternity registry. If you're going to have to do citation by publication, it's just like with every other case. You got to do your due diligence. You file your affidavit, get your court to order citation by publication. Also, as of 2020, it has to be posted on the public information internet website, which at this point, the court clerks know how to do that. I actually filed the first one, the juvenile courthouse that needed that, and that was fun trying to get that all figured out, but they know how to do all of that. You do have to have an adoption evaluation done in pretty much every adoption. If it's a private case, not involving an agency, you do file the adoption evaluation, not just in the adoption itself, but also in the termination suit. There's one potential exception, and that is we have a new code section went into effect with the last legislative session where it says that the court may waive a step-parent adoption after they've reviewed the CPS records, which basically, to my mind, would mean in a step-parent adoption, would mean criminal checks and child abuse registry checks. I will tell you, I do my work in the juvenile courts. They have not been willing to waive this. I have heard some of the family judges have waived it. It's one of those things that I just advise people, you're going to have to check with your court to see if they'll waive it. But it's only for step-parent adoptions, and you still should have the child abuse registry and criminal checks to show the court. And then, of course, if there was a CPS case, any CPS records. Adoption evaluations, it does say that the court shall order a qualified evaluator or family court services. I have providers I use that I know the courts will accept, so I don't actually get that order issued. But if you're going to use family court services, you have to get the court order to do that. And some evaluators, some of the home study providers will want a court order as well. You do have a pre-placement and post-placement, but those can be combined if the child's already in the home prior to you filing the suit. So a lot of times step-parent adoptions, that's the classic example, or those relative adoptions where a child's been in the home for a while. It's just combined into a single evaluation, not pre and post. Trial or prove up. Of course, if it's uncontested, you can do your simple prove up. Make sure you include any amicus and or ad litem attorneys. If you're doing a default, you got to have your service members affidavit. If you've done publication, you got to do a statement of evidence as well. If you're doing a contested, it could be to the bench or to a jury. A lot of my out-of-state colleagues that do this work are shocked to hear that termination of parental rights can go to a jury. Most states are like, no, that's a judge's thing. No, here you can get a jury for it because you can get a jury for pretty much everything here. And I call them the new discovery rules. They're actually not new anymore. I guess I should have taken that out. But remember that all the discovery rules for family cases apply to these cases. And again, you always, always, always have to prove up your best interest of the child, even if it's just a simple prove up or if it's a contested hearing. Your termination order, minor child is going to retain the right to inherit through the biological parents unless that order says otherwise. So if you're wanting to cut that right of inheritance off, you need to provide for that. You have to have a finding as to whether there is a court of continuing jurisdiction, and either state that the Bureau of Vital Statistics was searched, which it's actually really now the Vital Statistics Unit, but I think the code still says Bureau of Vital Statistics. Or you can say that's not required because if nobody's contesting jurisdiction, you actually don't have to do that search. So in my cases, again, newborns, I know there's no court of continuing jurisdiction. I don't go out and do that search. If it's an older child, if I don't know if I don't know for a fact that there is one, a lot of times I will still do that search. The termination order, you're going to appoint a permanent managing conservator if you're not doing an adoption combined with it, because obviously if you're doing an adoption combined with it, you skip straight to parent. I recommend that you specify the rights, including the right to consent to adoption. You can just reference the code sections, but I actually list them out. You do not have to send the birth parents a copy of it. There's a 30-day appeal period. And again, I mentioned earlier, if a parent has signed a voluntary relinquishment or waiver of interest, they can't attack this after 6 months, because unless they can prove, and even in that 6 months, they have to prove fraud, coercion, or duress. As for sealing the record, most courts will seal the record whether they want you to or not. Dallas County, pretty much every court I've been in Dallas County seals the record. It's just a county rule. So those records are likely to get sealed. Can make getting certified copies a little tricky if you're the regular family courthouse, George Allen, as opposed to it's a juvenile courthouse, but it is sealed. So in the termination case, you likely will need an amicus attorney if it's not a CPS case. In CPS cases, an amicus attorney would be the same as a guardian attorney, an attorney ad litem in a dual role. So this is representing child's best interest, like a guardian ad litem does, but has similar powers and duties of an attorney ad litem, including they have to interview a child who's 4 years old or older. But they are more like a guardian ad litem in that they represent best interest and are not bound by the child's expressed objectives. There's some confidentiality and limited liability. Those are all covered in the code. Pretty much every termination case over at the juvenile courthouse, which is where most of my work is, they require amicus attorney on all terminations. In other courts over at George Allen or in other counties, it just depends on the judge because it is a discretionary appointment. So sometimes if you've got, say, a step-parent adoption where bio parent whose rights being terminated does relinquish, maybe the judge won't require an amicus, but you'd have to check with the court to know for sure. In department cases, CPS cases, that's the only time you have a guardian ad litem. Now, I will tell you, some judges will still call an amicus attorney a guardian ad litem. They're not. It's different. Guardian ad litem is only supposed to be appointed in TDFPS cases, and that's mandatory. And then if the guardian ad litem is an attorney, they also serve as an attorney ad litem in the dual role. Guardian ad litem, again, focuses on best interest. Attorney ad litem on the child's expressed objectives if the child's old enough to express them. If you've got a 10-year-old kid, yes. If you've got a 2-month-old, no, then you default to best interest. And if those do conflict and you're in a dual role, and I had this happen once, where I was in a dual role, I had to have the court appoint someone else as the guardian ad litem, and they actually appointed CASA. So the CASA took over the guardian ad litem role. Attorney ad litem for the parents. So this is only mandatory in department cases, so CPS cases, for indigent parents. It's also mandatory if you do service by publication, you have to have an attorney ad litem appointed to double check the due diligence. It can be discretionary for an alleged father that you're terminating based on the paternity registry. It's mandatory for CPS cases, but in other cases, it is not. If you are appointed as attorney ad litem and you are representing an alleged father, you need to make sure you check for the paternity registry. If you're checking on publication, the due diligence, things like that. I will tell you, in private cases, if an indigent parent comes forward asking for an attorney, the judge usually will appoint one and will usually require the petitioners, which would be the adoptive parents, to pay those fees. I have run into that more than once. So beware, that is also, or even with a private agency case where they required the agency who is the petitioner to pay the attorney's fees for the ad litem. The state only pays for the ad litem when it's the state TDFPS and CPS pursuing, or the petitioners. So be aware of that. Step 2 is the actual adoption piece. So this can be combined with the termination suit like we talked about before. I don't recommend combining it unless the child's already been in the home for 6 months or pretty close to it, because otherwise you can get your termination suit done within a couple of months. Adoption, child's supposed to be in the home for 6 months. You want to get your termination suit done. So majority of my cases, other than my step-parent cases, are going to be where I'm doing termination suits separate. But if you are combining them, which you can do, you're going to need to make sure when you're doing all of your court documents that you're listing out both pieces. So you're basically combining a termination petition and an adoption petition. So everything that goes in one If everything goes in the other, you're going to put them together into a single petition. Again, the UCCJEA doesn't apply to adoptions. So if that is being filed separately, termination's already been done. Now you're filing adoption, or maybe you didn't. Well, if you don't need termination, it doesn't matter if it's, but you can file it either in the court where the termination was done or in the county where the child or petitioners reside. So, for example, let's say it was a CPS case, termination was done in Harris County, but the family lives up here in Dallas County. You can do the adoption up here in Dallas County. You do not have to go back to Harris County because it's not a continuing jurisdiction, truly a continuing jurisdiction issue. And you don't have to transfer it. That is what that 103001 says. Is you don't have to transfer it from the court that did the TPR. Now, if you've got scenarios where interstate cases, this happens for us a lot with one of my agencies with interstate cases, and the family wants to come back and finalize here in Texas, they just come back and do it in the same court that did the termination rather than doing it back home. Okay. If the petitioner is married, spouse has to join in the adoption. This is true also in adult adoptions, which we're not going to talk about too much, but it is true there as well. If the petitioner, prospective adoptive parents, are not already managing conservators, so that's usually going to be a scenario like CPS cases or private agencies. You have to have written consent of the managing conservator. In a step parent case, obviously your managing conservator is going to be one of the petitioners as the spouse of the adopting parent. So you don't have to have separate written consent there. If the child is 12 or older, they also have to consent in writing or in open court. They are supposed to attend the hearing. In fact, it's required unless the court finds it's in their best interest not to be there. So if it's STARS testing or something, you can usually get the court to waive that. But then you definitely have to have written consent as opposed to just an open court. Both petitioners should be there, can waive if it's, quote, unduly difficult. So back in the day when we still did most of these hearings in person, because now most of these adoption finalizations are done virtually, prove ups, I would have out-of-state families and just one of the petitioners would come back to do the final adoption because it was too hard to fly back both of them with the baby and all of that. So the court would routinely let me do that. But now that we're doing it by video, it's pretty easy because everybody can just be there on the video. It's one of the pluses. Required documents that have to be filed in the adoption. So as with termination, you do have to have an ICPC affidavit. You need that UCCJEA 152.209 affidavit about where the child's lived in the last 5 years if you've got parties in different states. If your termination was a separate action, you need to have that termination order. If it's, say, a step parent adoption and the other bio parent is deceased, death certificate. Your adoption evaluation pre and post as it applies. Health, social, education, genetic history report. That has to be done in every case except, and this is like the ICPC exclusions, step parent, grandparent, aunt and uncle, adult sibling. Don't have to do it for those. And that is the relationship to the child. Criminal clearance on the adopting parents, that it needs to be dated within 12 months. So a lot of times with some of my cases, when the initial pre-placement study was done and the criminal checks were done there, by the time we get to final adoption, it might be more than 12 months old. I have to get those updated. And then, as we talked about, consider managing conservator or child as applicable. The court order. So you need to include finding that all the requirements have been met. Be specific. So in my court order, it's going to say, pre-place, ICPC complied with and affidavits on file. UCCJEA affidavit on file. If it's not needed, I don't leave that in there, of course. Consent of the managing conservator, consent of the child, adoption evaluation, pre and post, the HESIG, the criminal checks, all of those things. I have separate sections for those different things. You do need to state the adoption is in the best interest of the child. And if you've combined it with the termination, you need separate statements on best interest. You have to have a statement that it's in the best interest to terminate parental rights, and you have a separate statement that says adoption's in the best interest, because just because one's in the best interest doesn't mean they both are. You need separate statements. You can include a name change for the child. And of course, most adoptions, that's pretty common. If I'm not changing the name, I usually just include a confirmation of the child's name so that it's clear we didn't forget about a name change. We're saying, no, we're not changing the child's name. It's still going to be whatever it is. So that's more common, like with step-parent adoption, where it's stepmom is adopting, so the child's last name isn't affected. I have had a few other cases where they chose relative adoptions where they did not change the child's name. And then again, sealing the record, that's an option, but in Dallas County, they seal all of them, always. And I think that's also true in Collin County, Denton County, Tarrant County. I don't really work beyond those, and I don't even work in Tarrant County anymore, but a lot of counties are going to just automatically seal them, whether you put it in there or not. Amending the birth certificate. So once the adoption's complete, birth certificate needs to be amended. There is a certificate of adoption form available through the Vital Statistics website. It's VS 160. They came out with a new form earlier this year. So if you've got a form from before, don't use that one. They will kick it back. You need to have the new form. That form does get certified in the court. It has to be signed by your family. It includes, dang, this is this. I knew there was a slide I needed to update. This is it. The certificate of adoption form now includes the application form. So it's not actually a separate document anymore. If the child's born in Texas, you're going to fill that certificate of adoption form out. It gets signed, it gets notarized, it gets certified by the court. You send it down to Austin to get the birth certificate. I do recommend expediting it, because even expedited takes about 3 to 4 months. If you don't expedite it, I'm hearing it's 6, 8, maybe even a year. Also needs a photocopy of the ID of the parent who signed it. That VS 140 form, that one doesn't exist. Well, you don't need that anymore because it's now been combined with the 160. I knew there was a slide I needed to change. Dang it. If the child was not born in Texas, I still get the certificate of adoption form done and certified, but I send that off along with a certified adoption decree and whatever form the birth state may require. And I check that in advance. Some states have their own version of a certificate of adoption, and I'll get that filled out, plus the Texas version, plus a certified copy of the adoption decree to send off to the state where the child is born, because that's the state, of course, that issues the new birth certificate. And that gets us through my slides. So we still have plenty of time for questions. Let me escape out of this and get back to you so that we can go to the questions. And it looks like so far there's only one in the Q&A. It says, are amicus attorneys appointed when both parents sign waivers and voluntarily terminate? In the juvenile courts in Dallas County, yes. Those courts will appoint an amicus in every termination. In other courts, you would have to check and see whether or not the judge is willing to waive it or if they want one. Some judges will want them in all terminations. Some might say, no, I don't need that if both parents are signing and voluntarily terminating. After the adoption is completed and the adopted parents do not want to change the name, do you still file a certificate of adoption? Yes. And even if they aren't changing the name, don't they want the new parent listed on the birth certificate? So you're still going to be filing to amend the birth certificate to list the new parent and potentially remove an old parent. I've never had a scenario where they didn't want to put the new parent on the birth certificate, except for an adult, where we didn't do a name change and they didn't want to change their birth certificate. We didn't do it there, but adults adoptions are a little bit different. Do these same steps and procedures apply to same-sex marriages and couples? As of right now, yes, they do. If it's a married couple, it doesn't matter whether it's same sex or not. If they're not married, judges, you might need to be a little more careful because some judges may not be friendly to it if they're not married. But if they're married, they have to be treated the same. And so it is the same. What about if it's a same-sex couple who already have both parents listed on the birth certificate? So I'm going to guess in this scenario, you're talking about a same-sex female couple where one of them carried the child. And they're married, so under the presumption, they are both put on the birth certificate. Now, there's some case law out there in the divorce context that would say that the paternity presumption for a spouse should be applied to a same-sex spouse just the same. And that's all good and well. But there are a couple of issues against that and why I still recommend doing a second parent adoption for those couples. One is, what if it's not in a divorce context? What if it is bio mom dies and her family tries to swoop in and take this child and tries to fight it? And then you got a big, huge fight. And you get a judge who is not sympathetic. Potentially a problem. Another is current politics. And I don't want to get too political, but with the current political climate, a lot of my LGBTQ clients are incredibly nervous. If you have an adoption decree, because with the birth certificate is essentially is just presumption. Presumptions can be rebutted with DNA. An adoption decree, on the other hand, is a court order. So I still recommend for my same-sex couples where one mom carries the child, even if they're both on the birth certificate, that we do a second parent adoption. So hopefully that answers that. Okay, private step-parent adoption in Denton County. Do I know if they will do? I do not know if Denton will require an adoption evaluation. You would have to check, if you know what court you're in, contact the court and ask if the judge will waive a home study if you provide the criminal check and the child abuse registry check. Those are things that the clients can do on their own. I also do know a home study provider who will provide that service for step parents to get the child, help them get the criminal check and the child abuse registry check without doing a full-blown study. So you can always contact me if you need that contact. But you need to find out from the judge whether or not they're willing to waive the full-blown study. Now, if you mean, will Denton County, like Family Court Services or their equivalent thereof, do the evaluation, I have no idea, because I've actually never used Denton County's equivalent. I've used Dallas's in the past. I try not to do that. I try to use private providers because they tend to be faster, much faster. Can I provide a list of names or companies that do adoption evaluations? So I have 3 people based in the Dallas area who are all properly qualified to do them. If you want to email me later, I can give you those names. So you can email me. My email is Jenny, Jenny, at womackadoptions.com, WOMACKADOPTIONS.com. Joe, my friend. So, do you still have to do a relinquishment? Presumed dad has done a DNA to support he is not the father. No, if you have a DNA test that shows presumed dad is not the father, whether it's DNA on him, excluding him, or DNA on bio dad that says this is dad, you can rebut the presumption and he doesn't have to do a relinquishment in that scenario. In fact, Joe, I've had that case. I don't know that you were amicus on it, but you can absolutely do it that way. Okay. Let's see. I think that pretty much covers it. I will say, kind of going hand in hand with that question, if you have a presumed father who isn't signing a relinquishment and you don't have DNA to use to rebut the paternity presumption, you will have to serve him. If it's a scenario where it's this estranged husband, she doesn't know where he is, you can't find him, you might have to do the publication route and all of that. But a presumed father, you either are going to have to rebut it with DNA, get him to sign a relinquishment, or serve him and deal with him. Usually in those scenarios, I've had to do publication and they don't, of course, show up and we move on. So I think I got all 7 questions.
Thank you, Jenny.
And we still have 13 minutes, so I still have time to answer more.
Yes, so
You
please
see,
enter
Maricela put the course number in the chat.
Yes.
Which you're probably coming on to tell everybody.
If anyone has additional questions, please feel free to enter them in the Q&A. For MCLE course credit, the course number is 174257143. Again, that is 174257143. Thank you, Jenny, for a wonderful presentation. A couple of housekeeping items. A copy of the PowerPoint will be emailed to all the attendees today, as well as the course number. So if you didn't get to write it down now, an email will be sent to you within the day of this presentation. I don't see any additional questions come in. But would you like me to go ahead and enter your email in the chat, Jenny?
Actually, I was just going to do that.
Perfect.
So I'm going to put my email in the chat. I got to change it. I don't think it lets me put it in for everybody, so you might have to, because it's just saying hosts and panelists.
Okay, I will copy it.
So why don't you do that, Maricela, because it looks like I can't do for everybody.
No problem.
Here's another question. Can the HESIG be waived in CPS cases? No, the HESIG can only be, the only time you don't need a HESIG is if it's step-parent, grandparent, aunt, uncle, or adult sibling. Otherwise, you have to have one, and CPS usually does something. It's usually a HESIG on the child as opposed to on the birth parent based on child medical records and what have you. But CPS should be providing that unless it is falling with one of those exceptions where you don't need one. They may not call it that. Sometimes they call it something else, but they should be providing that. Okay, let's see. Here's another one. Will the slides be shared? So yeah, Maricela already answered that those will get sent out. Where do you get the new certificate of adoption, the one in Dallas? Go to the Vital Statistics, Texas Vital Statistics webpage and get the certificate of adoption. It'll have you can get it from their forms page, and it's VS-160 is the form number. But yeah, Vital Statistics, yeah. Don't go looking at Dallas County, because yeah, I'm actually the one that told them there was a new form, or at least over at the juvenile court. So yeah. Make sure you're getting one. It needs to be, I think it came out in March of this year, but it'll be a 24 revised date for sure. It was either March or May. I can't remember which. Okay.
Awesome. Well, I did enter your email in the chat. So if anyone else has questions following today's presentation, please feel free to email Jenny directly. But we thank everyone for tuning in this afternoon, and we hope that you join us for our next one, which will be the last one of the month, and it'll be on guardianships. So thank you, Jenny, for everything, and we hope everyone has a good rest of your afternoon.
Thank you, Maricela. Appreciate it. Thank you, Kathy.
Thank you.
Bye, everyone.
Very much, Jenny.
Bye, everybody.